Butler v. State, Florida Supreme Court, 1986. The principal instruction can be given when there's evidence adduced at trial, when the defendant actually helps somebody else further their crime or commit some sort of affirmative act in the attempt to further the crime. In this case, there is not that evidence. The state in this case requested the principal instruction based on an opening statement of defense counsel. In the opening statement, defense counsel for Mr. Billups stated that the friend, Mr. Barton, may have been the person who committed this act. As the court knows, what an attorney says in a trial is not evidence, especially in an opening or closing statement or closing argument. During the testimony, there was no evidence whatsoever from any witnesses that Mr. Barton was assisted by the defendant in committing this act. In fact, Mr. Barton testified that on this day in April of 2018, he was called by Mr. Billups to go around and do what they do as friends. They were going to go get something to smoke. They were going to go to Mr. Barton's girlfriend's. They were then going to go over and help his friend, the alleged victim in this case, Melanie Woodward, with her car. During that whole day, there was no mention of any act by the defendant to assist Mr. Barton in committing this crime. Furthermore, there was no testimony that Mr. Barton, in fact, got out of the vehicle to commit this crime. It is not so much of whether the jury was confused by this or not, but whether there was a capability of the jury being confused by the principal instruction. More importantly, when this instruction was given, the trial court determined that he would go back at the end of the case and see if the evidence supported this instruction given. That, in fact, did not happen. When looking at this,
well, whose job is that to remind the court? I'm trying to find a legal objection that was made by the defense, and I can't find one. I'm at 290 transcript, and the only comment is, I don't understand how that would be the case, Your Honor. Are you arguing that's a legally sufficient objection? I don't see one legal word in there.
We are, Your Honor, we're saying that that was enough to preserve it as far as an improper instruction. Furthermore, with the court stating that they would go back and review it, it would be our position that the defense counsel had preserved that objection.
Well, that's just like a motion in limine. If the court reserves ruling, it's your responsibility to make sure the court rules. Did the defense counsel below get a ruling?
I don't believe so, Your Honor.
So you didn't remind the court of what the court had said. So you didn't give the court the opportunity to rule on it.
Well, defense counsel in that position, Ms. Ibanez, who tried the case, stated that at the time there wasn't enough, and at that time the principal instruction shouldn't have been given. And then the trial court decided to do so. And there was no reminder to the court at that time, but still it is the trial court's position and the trial court, and at least in our opinion, duty to give that instruction only when there was evidence that was properly admitted in court, which there was not.
But at 366, when the court finishes instructing the jury and asks if either party has an objection, the defense counsel says none, Your Honor.
Correct, Your Honor.
Okay, how's this issue preserved?
We would attest that, one, it was preserved prior to when the objection was made. And even if not, just the fact that it was given gives that there was an error which should be reversed on the basis of the capability of instructing the jury. It wouldn't be the harmless, but it would be under the abuse of discretion, Your Honor. With regards to the principle, there's also no way to tell by the verdict form itself whether the jury convicted Mr. Billups based on the principle theory in and of itself. As a result, we would ask this court to reverse and give Mr. Billups a proper trial without the principal instruction being given. With regards to issue 2, it is our position the trial court erred when it allowed Ms. Woodruff, the alleged victim, to give an improper opinion of Mr. Billups' guilt and testify to improper character evidence. In the case at hand, Ms. Woodruff was allowed to give an opinion as to whether Mr. Billups himself performed this act. And why that's important is because there was no testimony whatsoever to state whether Mr. Billups, in fact, was the person who did this act. There was no identification. In fact, there was a child who testified that said Mr. Billups was not the person who committed this act. The child testified that this person that was standing by the car prior to the car going up in flames was not Mr. Billups. When Ms. Woodruff was on the stand, the question was, what made her feel, or what was in her gut as far as why this was, in fact, Mr. Billups who committed this act? And she testified that Mr. Billups was, in fact, guilty of committing this act. An objection of relevance was made at this time. There were further objections preserved on this issue. Now, the court allowed this, and it is our position that this was an improper opinion. Furthermore, this led to the improper admissible Williams rule evidence of prior alleged threats that Mr. Billups made to Ms. Woodruff over a year prior. It is Mr. Billups' position that these threats, as well as Ms. Woodruff's feeling of improper opinion, became a center point to the trial in the state's closing and rebuttal closing that resulted in his conviction. Mr. Billups' position is that when this improper evidence assigned by the improper Williams rule evidence was admissible, is enough for reversible error. In the case at hand, the court never went through the four-part process which is required under Robertson v. State. First, there was no 10-day notice as far as the Williams rule evidence that these alleged threats were made prior to by Mr. Billups. This notice would have given defense counsel an opportunity to ask the court or request the court to go through its four-point analysis in determining whether Williams rule evidence is admissible or not. If the court had gone through the improper rule evidence as far as the Williams rule evidence, it would have seen by position number one, by clear and convincing evidence, the state could not meet its burden that the defendant committed the prior crime. First, with regards to the alleged threats. The alleged threats were testified to have occurred a year prior from this incident. This incident happened in April of 2018, yet Ms. Woodruff testified that she had only known the defendant from November of 2017. So from April 2018 going back to April 2017 shows that these alleged threats supposedly happened at a time when these two parties did not know each other. Furthermore, there was never any action in that year that when Mr. Billups allegedly stated, "I'm going to burn your car," specifically to Ms. Woodruff's car, that he ever made any action on that. It is our position that the state could not meet its burden under the first characteristic or rule under the Williams rule of whether clear and convincing evidence the defendant committed these acts. As far as the second step, the prior crime meets the similarity requirements necessary to be relevant. It is our position that these alleged threats, as the testimony indicated, were made when these parties were together back over a year ago, supposedly, by Ms. Woodruff, and during the points of argument. It is our position that it was a statement that was made specifically to Ms. Woodruff's car, where in this case, it wasn't Ms. Woodruff's car that was set on fire, it was a third party's. The third point, and most important, is whether the prior crime is too remote so as to diminish the relevance. These alleged threats were made a year ago, according to Ms. Woodruff. During that time, nothing ever took place. And after these alleged threats were made, there was no evidence of any threats whatsoever. Furthermore, after this arson act, Ms. Woodruff and Mr. Billups ended up going away for a romantic week or weekend down to Miami. During that time, there was no testimony that Mr. Billups ever made any apology, any reference to any arson, or any mention whatsoever to any past threats or the crime here. It is our position that these would be too remote as to diminish any relevance whatsoever. The fourth and final prong would be whether the prejudicial effect of the prior crime substantially weighed the probative value. It is our position that this would. The prejudicial effect would grossly outweigh any probative value. This was an instance in where a threat was supposedly made over a year prior. That in itself, I'm sorry? Oh, I thought somebody was talking. I'm sorry. This was made over a year prior without any action to confirm it. Furthermore, there was nothing in the evidence to prove that Mr. Billups was in fact the person who committed this arson whatsoever. As a result, this was, under Mr. Billups's brief, nothing but improper collateral crime evidence. As a result, we ask this court to reverse the conviction and give Mr. Billups a new trial. Thank you.
Very good. Thank you very much, Mr. Garcia, and you'll have your rebuttal time after the state's argument. Mr. Siegel?
Your Honors, may it please the court, Jeffrey Siegel on behalf of the state.
Mr. Siegel, as with Ms. Martin, you need to get a little bit closer to the microphone. We're having difficulty hearing you.
Okay. I'll speak a little bit louder as well. Is this better?
Yeah, speak up though.
Yes, Your Honors. May it please the court, Jeffrey Siegel on behalf of the state. As far as the first issue here is that the evidence adduced at the trial supported the trial court giving the principal instruction. We have Mr. Barton driving the appellant to the gas station, having appellant fill up an empty bottle of water, a jug of water, fill up with gasoline. Then Mr. Barton drove the appellant to the victim's car. The appellant got out and set the car on fire, and then Mr. Barton drove away the appellant. So here we have Mr. Barton working in conjunction with appellant to set the car on fire. So the trial court's determination of giving the principal instruction, which wasn't objected to by the defense at the end, so it wasn't preserved as well, but the principal instruction was warranted here since Mr. Barton assisted and worked in conjunction with appellant in this particular case. As far as issue number 2, we would say that the opinion given by the victim here is harmless. We look at all the evidence adduced in this case and the permissible evidence that the jury could legitimately rely on, that appellant admitted to setting the car on fire shortly right after he had gotten inside the car and admitted to Mr. Barton that I blew up the car, let alone we have appellant going to the gas station, seen on surveillance video, emptying out the jug of water, filling it with gasoline, going to the car, setting it on fire, and then leaving and discarding of the gasoline jug, which was found later to have trace amounts of gasoline in it. And then when you look at the particular opinion, it was to set up the fact that the defendant had threatened the victim earlier before about setting the car on fire. And the trial court weighed the evidence there and determined that it was such a unique threat of setting the car on fire that it was determined to leave it up to the jury. And the jury here was to decide the remoteness, which was to really attribute weight to this particular threat. And the trial court determined it was enough to give to the jury. And as far as the Williams rule, it's not Williams rule. This is not a prior bad act. This is a threat. A threat is different from a prior bad act. Here, the defendant threatened to set the car on fire in the future, which the defendant ended up setting the car on fire in the future. And that's what we have here, Your Honors. As far as the judgment of acquittal, as I said before, the appellant set the car on fire. He admitted to it. If there aren't any questions at all, rely on our brief.
Very good, Mr. Siegel. Thank you very much.
Thank you.
Mr. Garcia, you have your 5 minutes of rebuttal time.
Thank you. May it please this court. With regard to the principal, again, there was no evidence that the defendant was in fact helping Mr. Barton or anyone else to commit this crime. If anything, it was Mr. Barton with the defendant who were just out doing what they normally do. Mr. Barton testified he had no knowledge of anything that was going on, and in fact testified that originally Mr. Billups stated as the day began that he was going to go over and help Miss Woodruff with her car. This was one of the chores that they had planned, along with getting something to smoke, help Mr. Barton's girlfriend with her car, and do other errands. It is our position that there was no evidence whatsoever to show that Mr. Billups aided Mr. Barton or anyone else to commit these crimes.
Mr. Garcia, you keep saying that, but you don't think that that is a legitimate inference that can be drawn from that evidence?
What, ma'am? I'm sorry.
You don't think it is a reasonable inference that a jury could draw from that evidence that they were together and all the other things that were shown on the video and all the other evidence that you just recited? You don't think it's a reasonable inference that he was assisting? You don't think that's a reasonable inference that could be drawn from that evidence? Because you keep saying there's no evidence and then you recite all the evidence.
Well, it is our position that there was no evidence of the defendant helping Mr. Barton or anyone else. In fact,
well, that would be an inference that would be drawn. So is your argument that that's not a reasonable inference?
No, respectfully, no, Your Honor, it's not, because again, this is not Mr. Billups helping someone else commit a crime. Whether this is Mr. Billups going and getting a ride from a friend to have other errands and both of them do errands, and then in fact, this event occurred, that is something different than actually the defendant helping somebody else help commit this crime. Furthermore, it is something where these gentlemen were together the whole day. And during this time, Mr. Barton said he had no idea what was going to happen besides the fact that Mr. Billups was going over there to help fix the car. That's different than as far as assisting or helping a crime. Mr. Barton never got out of the vehicle when they were at Miss Woodruff's location. So it is our position that Mr. Billups did not assist Mr. Barton or anybody else with this crime whatsoever. More importantly, this principal instruction was given after the opening statement was made, not with any evidence as far as testimony of anybody else being by that car. The only evidence was that Mr. Barton remained in his car and that Mr. Billups did all this either by himself or didn't do it at all, not assisting anybody else. So it is our position that the principal instruction should not have been given at that time. Furthermore, with regards to the Williams Rule evidence, it is our position that the threats made of "if you leave me, I'll burn your car" are in fact a collateral crime of threats or extortion, as we stated in our brief, and as a result do fall under Williams Rule. And when that Williams Rule 10-day notice was not given, and when the court did not go through the four-prong analysis, then in fact the trial court erred, and as a result we ask for a reversal. Thank you for your time.
Very good. Thank you very much to both of you. You will please press on the click to leave button, and we will then proceed to the next case, which is Sweeney versus Washington and State Farm.